Hi, my name is Donald Dennison, and I am an associate attorney in the Elder Law Department at Mandelbaum, Barrett. And in today's video, I'm going to talk about what does the word incapacitated mean in elder law. The purpose of this video is to lay out three separate topics that all kind of relate to the word incapacity. The first being, what does it actually mean, and what does it not mean? The second, I would like to provide you with some examples of incapacity. And then lastly, I want to talk about some of the tools in an elder law attorney's arsenal for dealing with issues involving incapacity or diminished capacity. So first, what does incapacitated mean? The word incapacitated is a legal word that means that someone has been adjudicated by a court of competent jurisdiction to lack the required capacity to enter into things like contracts or to generally manage their legal, medical, or financial affairs. The key word here is court, because if someone is incapacitated, that means a court has determined that the individual lacks capacity in all or certain areas of their life. Oftentimes, people misuse the word incapacitated by describing someone with, say, late-stage dementia, who on the surface is incompetent, but who has not been declared incapacitated by a court. So in that example, using the word incapacitated to describe someone with dementia is incorrect. So what are a few examples of circumstances in which incapacity may be present? The most obvious example is the one that I've already used, someone with late-stage dementia who has the inability to maybe verbalize their thoughts, who is nonverbal, someone who cannot make competent, good decisions for themselves in the areas of medical decision-making, financial decision-making, legal decision-making. But there are other certain, less than obvious cases that come in front of us on a day-to-day basis that involve sudden incapacity. For example, someone who is involved in a motor vehicle accident and who can no longer speak for themselves, or if they do speak for themselves, it makes very little sense to most of us. And then there are other areas where, as a result of mental illness or infirmity, someone cannot make good decisions for themselves. And certain vulnerable adults, potentially open to exploitation or influence. Sometimes in those cases, a person will be declared incapacitated as a result of their vulnerability to exploitation. And so what sort of tools are at the disposal of an elder law attorney when dealing with issues of incapacity or alleged incapacity? There are generally two methods that elder law attorneys approach this issue using. One is a more proactive approach, and the second is more of a reactive approach. In terms of a proactive approach to dealing with potential future issues of incapacity, an elder law attorney has at his or her disposal tools such as powers of attorney, living wills, healthcare directives, to address certain financial, legal, and medical decisions in the event the individual signing those documents becomes incapacitated later on. Just generally speaking, a power of attorney enables to appoint a surrogate financial decision maker for the principal in the event they can no longer make decisions for themselves. Similar to that power of attorney is a living will or advance directive for healthcare decision making, wherein someone can proactively appoint another individual to make medical or healthcare decisions for them before there is ever an issue of incapacity or alleged incapacity that may arise in the future. But what about the reactive approach? What about those cases where, for example, as a result of an accident or sudden illness or injury, someone has diminished capacity or they've lost the ability to speak for themselves, and then there's no power of attorney, no healthcare directive in place, appointing a third-party surrogate decision maker for them? In that case, sometimes we have to pursue a guardianship In other cases, we can pursue a conservatorship if the individual who's experiencing that sudden accident or illness is somewhat capable of consenting to the appointment of a conservator to manage their finances. There's also the ability to ask a court to appoint a limited guardian. And so all of these approaches are more of the reactionary approaches to dealing with alleged incapacity as well as incapacity as a whole. Generally speaking, it's always very good to be proactive. There's a real benefit for being proactive insofar as if you have a court appointing a surrogate financial or healthcare decision maker, it kind of removes you from the driver's seat. It doesn't allow you to pick who those people are or who that person is. And so by being proactive, you're able to hand select those individuals who are going to make sound, competent decisions for you in the event you become incapacitated later on. So as an elder law attorney, we deal with all of these issues having to do with being proactive and signing estate planning documents like powers of attorney and living wills. But we also handle those cases where maybe it's a little too late to sign a legal document, and we have to then petition a court for additional assistance in the form of a guardianship, in the form of a conservatorship. And so the elder law team at Mandelbaum Barrett is more than capable of assisting you with either approach, depending on your circumstances. So I invite you to reach out with any questions that you may have, and I look forward to speaking with you. Thanks.